Good afternoon. I'm Tim Lynch. I am your host here on Legal Lines. MLGBA Legal Lines is brought to you by the Massachusetts Lesbian and Gay Bar Association. I'm Tim Lynch. I'm a lawyer here in Massachusetts, and I bring this program to you live once a month. It's a new year, and I thought a good guest would be somebody who can speak to us about estate planning and tax issues, particularly as they pertain to same-sex couples. And I can't think of a better person than Lisa Cukier of the honorable and wonderful firm of Burns and Levinson here in Boston. Lisa, how are you?
Very well, thank you, Tim.
So Lisa, why don't you tell us generally what your practice area is?
Sure, I'm Lisa Cukier, and I practice in the area of estate planning and estate litigation, disputes between family members. I do some divorce and some custody. I represent people who are in blended families. Sometimes they're intergenerational, where somebody who's older marries somebody younger. Sometimes there are people who are adopted within the family, step-parents, step-children, half-brothers and half-sisters, and very often, because of the nature of blended families, there are family disputes that turn into litigation. So the type of estate planning that I do, and planning in general, is planning that helps couples and families to avoid litigation.
Well, plan ahead, and when everybody is, I suppose, in a better frame of mind.
Yes.
And to plan, it's wonderful that you do both ends then, and so you would be more in tune of what issues come up should it go to litigation.
That's right, and I'm a litigator, so when these matters do get litigated, I'm very able to handle them. And most of my work is litigation because the vast majority of people don't do the planning that they could do in advance to avoid litigation.
Well, what kind of planning would people do?
Well, there are different types of tools, estate planning tools that can be put into place, and different types of agreements that can be put into place to avoid litigation. So,
what's estate planning, though? What is that?
Estate planning is where a person signs certain documents that will provide for an orderly distribution of their assets, or that will provide for somebody to make decisions for them if they become incapacitated, such as a healthcare proxy or a durable power of attorney. And sometimes it can include prenuptial agreements. It can include cohabitation agreements for people who select not to marry. So these are the types of documents that I'm referring to when I talk about estate planning. It can be wills and trusts, but it's not limited to wills and trusts.
So what kind of issues do you face, particularly as they pertain to the same-sex couples, shall we say?
One issue that comes up is a situation where one person in a same-sex couple becomes ill and becomes incapacitated, maybe due to an illness or maybe due to an accident, but is all of a sudden not able to make decisions on their own behalf about their finances. And that person might want their partner or their same-sex spouse to make their financial decisions for them, but family members, biological family members of the ill spouse or partner might decide that it's their job to control the finances. And so you would end up with a dispute between a same-sex partner or spouse on the one hand, and family members, biological family members, on the other hand. So one of the documents that I recommend for my clients to sign is a durable power of attorney. And this document is signed by a person when we have mental capacity to sign it. So you and I can sign these documents, and we should have them as part of our estate plans. And it would designate a trusted person who we select to make our financial decisions for us. So we could designate our partner or our spouse to make those decisions for us, so that in the event, God forbid in the event, that we're unable to make our own decisions down the line, the person we select is the designated decision maker. And these documents are binding.
Well, what if isn't being married giving a durable power of attorney to your spouse? I mean, do you really need this document even if you're married?
Even if you're married. And this applies not only for gay couples, but straight couples too. It's part of a standard routine package. People who are over 18, who are adults and who are competent, can make all their own decisions. If they lose capacity, then a spouse can't just jump in as surrogate, as the substitute decision maker. There would need to be either a durable power of attorney for finances or guardianship or conservatorship, even for a married couple. So the least expensive and best way to accomplish this orderly distribution of decision-making is by having a durable power of attorney signed when everybody is competent.
Being very proactive, in other words, and as you mentioned earlier, avoid potential litigation down the road.
That's right, because the potential litigation would be guardianship litigation, and there'd be a situation where you have biological family members saying, I should be in control of my daughter's finances, versus a spouse or a partner. And if the ill person is not married, then it would be difficult for a partner to establish their relationship, because in the community we recognize marriage as shorthand for a special group of rights and certain presumptions. But if you're a same-sex couple who's not married, those presumptions don't exist. And so it wouldn't be difficult for family members, biological family members, to step in, come out of the woodwork, and prevent a partner from handling the finances of their ill partner.
So obviously a very important document to be signed by everybody.
Not only is it very important, Tim, but it's also very powerful. There was a case decided in 1996. It was argued by GLAAD, the Gay and Lesbian Advocates and Defenders, and the case is Guardianship of Smith. And the case did not involve anybody who's gay, but it's very instructive for us in our community. The case was about a gentleman who was married to a woman and had a daughter, and he designated his business partners as his agent under a durable power of attorney, so that in the event that he later had an accident and lacked capacity, his business partner